good afternoon or good morning, depending on the time zone that you're in. Myself and Shawn Johnson, a colleague of mine from Sedgwick, will be talking to you today about ADAA. Obviously, it's a very active area and a lot of court cases and a lot of changes going on with the Americans with Disabilities Act. And so we're going to take some time today to talk to you a little bit about what's all going on. So with that, Shawn, let's go to slide 3. And just to take a step back and talk a little bit about what is the Americans with Disabilities Act. So back in 1989, the first President Bush, with bipartisan support, signed into law the Americans with Disabilities Act. And basically, the simple premise was it was designed to protect individuals from job discrimination based on disabilities. So the intent of the Americans with Disabilities Act was definitely a good one. There was a definition of disability, and that was defined as a physical or mental impairment that substantially limits major life activity. And there was a third component as well, that when evaluating somebody with a disability, there should be a discussion with that employee with what later became called the interactive discussion, to talk about what they think they possibly could happen in the workplace to accommodate their restriction. So the law at that point was trying to make this to where the employer just didn't decide on their own, but have a discussion with the employee so that all parties had an opportunity to evaluate what may be available. It's also to be noted that the Americans with Disabilities Act covers all conditions. It doesn't matter if it's work-related or not work-related. If there's a restriction or accommodation need, that needs to be evaluated, and it should be evaluated in a consistent way. So the law goes into effect 1990, and much like any other law, as time goes by, there's challenges, there's court cases, and so what has changed since the original act? And really, again, there's been a number of, the Supreme Court has ruled in a number of cases, and over time, the initial intent of the Americans with Disabilities Act has changed, and changed it changed in a way that was not consistent with what Congress thought when they originally enacted the law. Just to give you a little sense of kind of how the law evolved, there were a couple court cases that I'll talk about here that really give you a flavor and led, as well as some other court cases, to Congress finally deciding they had to make some amendments. But there was one court case around two sisters who wanted to be pilots at an airline. The airline required certain vision, uncorrected vision of 2100 or better. The two sisters had contact lenses and glasses that could correct the vision to meet that standard. However, they were not hired for the job, and they eventually sued their employer under the Americans with Disabilities Act, saying they were not hired because of their disability, meaning their vision. The court looked at the case and ultimately ruled that because they had corrective glasses for their vision, it wasn't a disability under the Americans with Disabilities Act, and so they had no standing in that case. A second situation was a manufacturer who had an employee who worked in an assembly job. She had developed carpal tunnel. She was given a restriction, and for a long period of time, the employer had worked with the employee. She had a workers' comp claim. It was settled. Later, they put her in a new job to accommodate those restrictions. But over time, they had to change the requirements again of that job. And when they changed the requirements of her new job, she couldn't do that job. And so the employer finally said if she couldn't do that, they were going to fire her. And so they let her go. The end result was she also filed suit. The courts looked at the case. And in this case, they looked at the provision of how substantially limiting the disability potentially was, and they looked at specifically her activities of daily living, the activities of daily living that would require to do her job, but even broader, the activities of daily living that she would have to do around the house. And when the court looked at it, they felt like she could do many of the activities of daily living around her house, and so therefore it was not a disability under the Americans with Disabilities Act. So what we saw, and those are just a flavor of a couple cases, is the definition of the disability, while when first written was rather broad, the courts were ruling it and really tightening up the definition of disability. And so Congress finally got involved, and in 2008 they enacted the amendments to the Americans with Disabilities Act. And largely, the intent was, from where Congress sat, they felt like the original intent of the law and where it had evolved to were not in concert. And so they went to look to broaden the definition of disability, and sent out indications to everyone that the law is designed to be employee friendly. And it seemed like over time it went the other way. And the goal should be to keep people at work, and that every effort by the employer should be made to get that person back to work and accommodate them. In fact, much like I talked about in the first case, just because a condition is controlled by medication, by corrective eyewear, technology, it doesn't mean that it's not covered under the Americans with Disabilities Act. Another area that the courts had ruled on previously was if a condition was episodic in nature, and during a period of time when the situation when an evaluation was being made, if it was not active, some courts had ruled in the past then that it was not a disability under the Americans with Disabilities Act. The amendments cleared that up and said even episodic condition, even if it's not active, they need to be evaluated as if they are in the active state. It also included, under the major life activities, bodily functions, and if any of those are impacted, it could qualify under the Americans with Disabilities Act. So basically, Congress came back in 18 years later and basically reset the course and redefined what really the intent of this law was. And as a result, many of you as employers now have been laid with the challenge here now of being able to make sure you're following the new interpretation of the ADA. Obviously, there's a lot of challenges that face employers. Establishing accommodations can be a very, very complex process, can be a very challenging process. It can also, you have to be able to weigh the ability to accommodate a person versus the day-to-day needs of carrying out the business that you do. Another thing that is a challenge is with people spread out at many employers across different plants, different stores, different parts of the country, having a standard process to make sure that the process is followed by everyone becomes a very big challenge. Also, to have the appropriate triggers in place to ensure that the interactive discussion occurs, because as I mentioned earlier, that's a big component of the ADA. And then finally, one of the big challenges is a place to document. As I've said, there's been a lot of litigation in this space, and when as we all know, when litigation happens, we have to go back and document and see what all happened throughout the process. And so many employers struggle with a consistent place to document and store all this information, so if at a later time they need to provide it to an attorney, they have it. So all of those challenges and make following the ADA and complying with the ADA and the place that we're in right now very challenging. And so with that, I'm going to turn it over to Shawn to talk about some of the key steps in the process. Shawn?
Hi, we've come up with what we think are kind of the 5 pillars, if you will, of a consistent process and what will keep you out of out of trouble with the ADAAA laws. And so, as Darryl said, the consistency of following these steps for every case that is presented to you as an employer is really key, and having the documentation that supports them, all the steps that were taken, all of the interactive discussions that were had, really becomes what you need in order to ensure compliance. And so as we step through these, initially it's capturing that request. And so obviously, when an employee walks in and requests an accommodation due to something, that's one way by which you might find out about it. However, the other key is that if they have been out on some form of job-protected leave, however, they need to remain out longer, and they do in fact have a certified accommodation or a certified disability, then that's another situation where you need to make sure that they understand their rights and have been evaluated under ADA. So before the amendments were done, employers often used the end of FMLA time as what they thought was an appropriate time to be able to terminate employment if the employee was unable to return to work. And now what we know is that's not necessarily always the case, because those things oftentimes can qualify under ADA. So really capturing that request either from the end of the job protected leave or from the employee coming in and making a new request. And obviously, again, the robust information system by which all of that is captured in, what the request actually is, and what it was born out of. Next is the certification of the impairment. So under the law, you do have the right to reach out and determine that the employee really does have a disabling condition, and that they really would be able to perform their essential job functions if given an accommodation. So reaching out, getting the appropriate level of information. You can't ask for more than's needed in order to be able to certify that, but you can certainly request the information as it relates to that accommodation. The other key is having an individual who can really interpret and understand those accommodations. So oftentimes somebody with a vocational rehabilitation background can be very beneficial to understand what those accommodations that are being requested and how they relate to the disability. The other key to being able to really certify that impairment is to have a job description that truly outlines what the essential job functions for that individual employee are. And oftentimes employers struggle with this if they don't have well-documented job descriptions, and this is something that has to be done on each individual case, because without being able to provide the treatment provider with that information, it's very difficult for them to comment on what accommodation may or may not be able to help that individual perform their tasks. Once the request has been made and we've certified that it is in fact a qualified accommodation and disability, then it's about that interactive process. And that was the intent of the original law and has been even more highlighted in the amendments. And so essentially this is really discussing with the employer and with the individual themselves what exactly the impairment is, what the job functions that they are or aren't able to perform, and really having that discussion in order to figure out what the best course of action is. The one thing that we need to be careful about in this interactive discussion is that just because somebody is filing for a disability accommodation does not mean that they have to fully disclose their entire medical history. So really, they need to be told that they really only have to be willing to discuss those medical conditions and focusing on the limitations that are preventing them from doing their current job. And then it's helping them understand how and what accommodations might be available and how that would assist them to be able to do their job. Once those discussions take place, then it's about really figuring out what's the appropriate accommodation. Oftentimes for conditions, there could be multiple accommodations that could result in the employee being able to perform their job. And it's really up to the employer to choose the one that allows the employee to perform the essential functions of their job. The employer can choose the one that's most advantageous to them as long as at the end of the day it does allow that employee to perform their job functions. So if there's a significant cost difference between two alternatives, you certainly have the right to choose the lower cost for you as long as, again, at the end of the day, it allows that employee to continue on in their job. After those, after the suggestions and all of the different, all of the different options have been explored, then it's up to the employer to go back and determine what it would take in order to implement those different accommodations. So they're going to go back and they're going to work with their internal teams in order to figure out what accommodations are available and which ones they're going to choose to accommodate. At the end of the day, whether you have other partners involved in this process, it's important to remember that this decision of whether or not the accommodation is going to be made and whether that employee is going to remain within the workplace is an employment decision, and that always needs to remain with the employer. You can't really outsource that to any vendor partner. That really is always going to remain at the employer's discretion. And then after all those discussions have been had, after everybody is in agreement as to what the what the accommodation is going to be that's going to allow that individual to continue working, then obviously that needs to be implemented. And really, again, going back to the point of, this needs to be consistently done in each case. The entire process needs to be followed for every accommodation that is requested. And in addition to that, all of these steps need to be clearly outlined, documented, date and time stamped, so that oftentimes what will happen is a supervisor or manager, HR individual that's involved in these discussions may at some point leave the company, and while they were there was a full understanding of what had been agreed to and everything. But once that individual were to leave the company and a new supervisor manager comes in, that information is imperative for them to understand why and how the decision was made for this accommodation, so that the continuity of that accommodation exists even beyond individuals coming and going from the company. As Darryl said, the amendments to the law were really meant to keep employees at work. We actually heard from the director of the EEOC at a compliance conference earlier this year that really, their expectation is that all employees would be able to be accommodated, and it really is most likely a rare circumstance when there's nothing that can be done to accommodate the employee and keep them at work. And so from their perspective, it's kind of went the opposite direction of maybe what it was when it was first implemented, in that the employee really needs to be looked at, and their accommodation needs to happen in order to allow them to stay in the workplace. So if you're looking for partners to help in this process, there's different things that are key and important to consider when choosing those partners. Again, it's important to remember that this truly is a partnership. A service provider cannot take over this process for you. There are several key points within the process that the employer must remain a part of. For example, validating that we have the appropriate job description and that the essential tasks are outlined in that job description. The employer really needs to validate that that truly is the employee's function. They need to be involved in the interactive process, so that interactive process cannot just be a partner and your employee. You need to be involved in that and understand what those discussions are yielding. And then obviously at the end of the day, it's your employment decision. So it really is important to remember that this has to be a true partnership. But in that partnership, you should really look for a provider who can enhance the operational efficiency. So oftentimes this is, especially at larger employers, is kind of put out across all different pieces of the organization. And so really to bring some operational efficiency to that so that you have a single individual who's responsible for ensuring that the process is followed start to finish every time. Making sure that the processes are timely and that they're standard. So again, that they're consistent and that we're not taking an exorbitant amount of time in order to make these accommodation determinations. You should be able to see a reduction in your overall administrative costs for the program, as well as improving absence outcomes. So oftentimes, as we know, leave as an accommodation is a reasonable that can be seen as a reasonable accommodation. However, all absenteeism within an organization has costs to it. So the more we can control absenteeism and keep good, qualified, skilled individuals who know their jobs, doing their jobs every day, then that's going to improve the overall productivity for you as an employer. Obviously, lowering any litigation risk by triggering that interactive process review. So making sure, again, that goes back to the consistency, but if that interactive process doesn't occur, then obviously your risk of losing a litigated case is significantly higher. Back to the system of record, having a record of the requests, the reviews that were done, any documents, so both any documents that are sent out to the employee or to their treatment provider or received in from the employee or treatment provider need to become a permanent part of that file and easily producible if needed for litigation. And then obviously the decisions that are made, well documented, the rationale by which the decision was made is essential. And so making sure that all of that is consistently documented in a single system that is easily retrievable if needed. And then lastly, you really want to provide a high quality employee experience. So obviously these employees are valued as part of your organization. We want to make sure that they're treated with respect and that they are given the consideration needed and that they haven't had to jump through a lot of hoops to really get what is due to them. So really just making sure that they have somebody who is consulting with them, helping them understand the process, and really providing an exceptional level of customer service from them. One of the other challenges that we're seeing that some employers are dealing with is, this is, as we mentioned earlier, this applies to both occupational and non-occupational disabilities and injuries and illnesses. So across the disability and workers' comp, there really needs to be consistency, again, with how these are handled. If a service provider is offering those services, then obviously having that consistency across all of those lines of business is advantageous for both you and your employees. Again, that goes back to a single employee experience, so they're having the same experience whether they were hurt on the job or just have some other life event that is causing their disabilities. So that's really how Sedgwick looks at ADA and how we help clients stay in compliance, how we help them stay out of litigation issues that may arise, and really what we've seen in the marketplace as far as where the industry is going from an ADAAA perspective.
All right, Shawn, thank you to both you and Darryl for the great information today. I know with all the ground we've covered, we want to give everyone on the line a chance to ask you their questions, and it looks like we have some already starting to roll in. So everyone, please, if you have questions, continue to type those in the Q&A panel on your WebEx screen, and I'll go ahead and get us started with some of the questions here that we've had submitted from listeners. The first one comes from Hannah Gifford. And she asks, after FMLA leave is exhausted, does the associate have to ask for an additional accommodation, or should it be automatically discussed once the end date is approaching?
Yes, so our recommendation is that they're at the end, at the exhaustion of the FMLA, that is offered up if they feel like they have a continued need, that they be offered the ADA accommodation at the end of that. So really, once the employer knows that there is the potential of that, they really have an obligation to educate their employee for exploring of that.
Okay, the next question comes from Cheryl Sinclair, and she says, we have inconsistent information, but should HR work with the employee directly to obtain medical information, or with an authorization can we obtain directly from the doctor?
Well, I don't know that we know your exact, process. Obviously, if you were going to reach out on your own, you would need a release of information to obtain that information. However, I think if you just go back and look at the amendments and the focus of the amendment, it's supposed to be a collaborative process. So what we normally see is we would have if there was information that was unclear, we would talk to the employee, and then if needed, we would reach out on their behalf and try to find out, try to get the information to clarify it.
Okay, thanks, Darryl. The next question comes from Kathy, and it looks like she has a specific question about someone in her workplace. So would we have to accommodate an employee with a mask if they have a dust allergy, or would we be able to accommodate them to bring and wear a mask so they could be able to work with the paper copier we're asking them to use? So kind of a specific question there.
So if that accommodation can be made and they can still perform the essential job functions, I guess I would need to understand a little more. We would need to evaluate a little more what their specific essential job functions are and whether that mask is able to prevent the allergies and allow them to do their job. But if that is, then yes, that would be a reasonable accommodation.
I'm not sure if maybe the question is providing one or having them bring one. Maybe that's another portion of the question you can kind of address, if possible, there.
Oh, I'm sorry, if the employer has to provide?
Yes.
Is that the question? Yeah, that would be just like in my opinion, that would be just like an adaptive keyboard or something along those lines, is that the employer would provide that in order to allow them to do their job.
Okay, thank you. The next question comes from Anthony, and he asks, what is the alternative determination if the employee can't remain in the workplace?
So essentially it becomes an employment decision. So if the employee cannot be accommodated, or if there is no accommodation that can allow them to perform their essential job functions, then essentially it's a termination of employment based on that.
Now what we see is we do have employers, though, where we see is oftentimes putting them on some type of, even after their FMLA, they may put them on a personal leave or some other leave for a period of time to make sure the condition is not one in which it could change in the short term. But if it's not a condition of that nature, then ultimately it could be termination. Now, again, the changes didn't mean you can never get rid of an employee. So there are going to be situations, obviously, where you can't accommodate, and the end result may be termination. It's just, I think, as we talked about, kind of how it was being interpreted from 1990 to 2008 was probably was much more tighter than originally intended.
Okay, we have a question from Amy, and she asks, is authorization to release medical information form, the form for that, necessary for obtaining medical certification from the employee to verify the ADA qualifying disability?
Well, yeah, I mean, any time that you're going to request from a medical provider, they're probably going to ask for a release of information from the employee.
Yep.
So, I mean, that's just like any, a disability or anything. When you're going to that physician for records, they're going to request that release of information. So that would normally be one of the first things that we would send out to the employee to have them sign and return to us so that we could assist in getting that information.
Okay, here's a question from Selena. She asks, are accommodations specific to the workplace only, or does it include working at home also?
Meaning, is that I'm sorry, I don't know if I fully understand the question. Telecommuting has been actually a lot, as far as a reasonable accommodation can be telecommuting. So rather than coming into an office every day, that can be seen as a reasonable accommodation. However, again, depending on the nature of the work and whether it can really be done from a telecommuting situation, has to be reviewed under, for that particular employer to determine if that truly is a reasonable accommodation in their situation.
Okay, thank you. Raymond asks, does Sedgwick's platform integrate workers' comp, FMLA, and ADAAA systematically when all three elements are overlapping?
Yes, all of those are completely integrated within Sedgwick so that we have, you can see all of the pieces of the puzzle within the one platform.
And a follow-up from him as well. Does Sedgwick's ADAAA platform include vocational or ergonomic experts that assist employers in determining potential job modification?
Yes, we have what we call job accommodation specialists who all have a vocational rehabilitation background. And so when we're assisting clients with ADA and return to work solutions, they are part of that. And they do help in the evaluation, both with the certification and then the evaluation. They can do workplace evaluations and determine what accommodations can be made.
Okay, we have a question from Lisa. She asks, what if an employee does not meet the requirement to provide certification within a specified time frame? For example, DOL recommendation 15 calendar days. Does an employer have the right to deny the accommodation or leave? So for leave, are you, I guess I'm curious if she's really talking about FMLA or if she's talking about ADA. Because under FMLA, you do have the right to deny the leave if they don't report within, don't certify within a specified period of time. However, if they come back and support and provide documentation later, you do in fact have to certify that going forward if it meets the definition of the serious health condition. Okay. Let's see, we have a lot of questions coming in, actually, so let me just catch up here really quickly. I'll get this question here from Tyla Tran. How does an employer accommodate a request for intermittent leave for flare-ups if the employee either exhausted their FMLA entitlement or is not eligible?
Well, again, because leave can be a reasonable accommodation, they could potentially still be eligible for that, and that does not have. I mean, that's beyond their 12 weeks of federal entitlement. So they could use that intermittently going forward as protection. Now, it's important to remember, and I think that sometimes this gets lost, in translation of having to having to accommodate and keep those employees in the workplace. They still have to be able to perform their same job functions and the productivity level has to be the same as well. So you don't have to lower their standards for what they're required to meet from a productivity level. So that's something to consider, is that if they're not meeting those standards, then that accommodation isn't necessarily allowing them to do their job as defined. So that's something to keep in mind, that if they're constantly away from work and cannot meet their productivity levels or get their tasks completed that are appropriate, then that accommodation is not allowing them to truly perform the essential job functions. So that's something that you can look at.
Okay, here's one that I think is a follow-up to an answer that you provided a few minutes ago, Shawn, but here's from Lynn. She asks, how long do you extend time after the FMLA has been exhausted?
Well, there's really no set specifications. Really, that's meant for conditions that could change, and so a reasonable amount of time. There's varying, I think, opinions out on what that means. Some people look at 90 days. Some people look at 6 months. There's really no clear-cut definition of how much time that is, and it's really about determining whether a reasonable amount of time is going to truly allow that individual to come back into the workplace and do their job.
Okay. We have another question. This one is from Chantal, and she says, I have an employee who does not wish to start the interactive process with her physician. However, her absenteeism is excessive due to back problems and other personal issues. Any advice on how to handle a situation like this?
So they didn't want to start the interactive process, or don't want to start the process at all? I guess. She
said not wishing to start the interactive process with her physician. So
it sounds like in that case with the physician, because the interactive discussion is more between the employer and the employee, not with the physician. But fundamentally, though, there has to be some medical proof that the person does have a valid medical condition that needs the accommodation, and so that is incumbent upon the employee to help provide that information. If they can't provide the information, then there's no way to validate if the restriction is actually appropriate. So, I don't know if they've asked if they could, if the person asking the question has asked their employee if they could reach out to the doctor themselves, maybe have a release sign, or have the employee call the doctor and say that the employer will be reaching out to get the information. So don't know if that's exactly the question, because the interactive discussion wouldn't be with the provider, but it sounds like maybe the challenge is actually getting information from the provider.
All right, thank you, Darryl. This one, I believe, would be a follow-up to another question Shawn's answered as well, and this comes from Janine asking a little more about what credentials our ADA and ADAAA experts have.
That are helping to assist with the process. Our job accommodation specialists are generally certified rehab specialists.
I think you can explain a little more about those credentials there, sure. Sorry,
the certified rehab specialists. Those so there's an actual designation required that, and they have to keep up, much like a clinician. There's actual courses for that designation, along with continuing education courses that have to be taken. They're licensed for all of our colleagues that we hire into that position. We require that they have that license within their first year of employment with us, and then that they maintain that on an ongoing basis.
Okay. Here's a question from Heather. If an employee has received a permanent and stationary rating from a work comp injury, does there need to be a separate interactive process meeting for both work comp and ADA, or can it be the same discussion to cover both?
Sorry, can you repeat the beginning of that question, Amy?
Sure. She says, if an employee has received a permanent and stationary rating from a work comp injury, does there need to be a separate interactive process meeting for both work comp and ADA? Or can it be done in the same discussion?
Yeah, in my opinion, as long as it's well documented that both the discussion regarding workers' comp and ADA have all been sufficiently covered, that doesn't necessarily have to be two independent conversations.
The key is the documentation, making sure you clearly explain to the employee that you're evaluating it under the ADA as well.
Okay, thank you, guys. Brittany asks, if an employee is using FMLA intermittently and exhausts their FMLA, does ADA still protect their full-time status, or can a reasonable accommodation be changing their status to part-time?
Well, the intent of the law is not to change their job duties. So if they're going from full-time to part-time, then you're essentially changing what their productivity output levels expectations are. So again, if you have part-time work available and can keep them, there's nothing to prevent that, but that's not really, in my personal opinion, what the intent of the rulings are.
Okay. Susan asks, if the employee does not qualify for a leave of absence due to short tenure of employment, less than 90 days, would you still want to consider an ADA leave accommodation? Just confirming.
Yes, the leave accommodation is not tied to the same eligibility rules as what like federal and other leaves are.
FMLA is different. The requirements under FMLA are different than ADA. You'd want to evaluate that under the ADA.
Okay, here's a question from Tony. She asks, if an employee asks to be moved to a different work location to be closer to her doctor's office, does that request fall under ADA?
Well, again, you'd have to evaluate the individual circumstance, but she would have to have a medical condition that, to be closer to the physician's office. I'm not sure how that would necessarily, qualify, a medical condition that would qualify that as an accommodation. However, each case really has to be looked at individually based on what the underlying condition is and what truly is causing the employee to not be able to perform her job tasks. On the surface level, that doesn't sound like it would be, but again, without knowing the specifics of the medical facts of the case, it's really hard to, say for sure.
Okay, next question is coming from Anna, and she's asking for some additional suggestions on how to manage the conflicting requirements between ADA and workers' compensation. So, for example, allowing the employee to continue working while the company conducts the interactive process, while in workers' comp, some states require job offers to be provided to the employee prior to them returning to work with restrictions. Is there any clarification you can provide there on those conflicting requirements between ADA and workers' comp?
Well, again, there's nothing, from an ADA perspective, the employee can either remain at work while that process is is going on, or oftentimes until an accommodation can be made, we might see them actually be placed on leave until the appropriate accommodation can be determined and implemented. So it might be a combination of leave as a reasonable accommodation for a short amount of time while that gets while that new position or new accommodation is able to be implemented. So I'm not really sure that they're in direct conflict with one another. Obviously, most courts are probably going to rule to the favor of the employee. So if they're, and I'm not the workers' compensation expert at all, but if there is a state out there that says that an employee does not have to return to work until, you know, the job is available to them, then obviously we would, you know, probably counsel towards going in favor of the employee in that particular situation.
Okay, next Jean is asking us, can we expand on what constitutes a hardship to the employer?
Well, typically, you know, it's probably going to end up being a financial hardship, and you know, from what we're hearing from kind of the EOC and what they're saying at compliance conferences and such, it really is going to have to be proven that in order to do that, it puts you in financial risk. Essentially, so it's really, in our opinion, it's very difficult to prove hardship from that perspective. I mean, you know, buying a piece of equipment, those types of things are probably not going to ever be considered a hardship if all of a sudden you have to redesign your workplace in order to, you know, accommodate somebody, and that truly is a significant financial cost, then that could be seen as a hardship. But again, that's going to depend on the size of your employer, because if you're a very large employer, you can probably do a lot that isn't going to really, at the end of the day, impact you financially. If you're a little bit smaller employer, then doing some of those types of modifications could, in fact, you know, perhaps be seen as a hardship. But according to, you know, all that we've heard this year, it really truly would have to negatively impact the, you know, the finances of your organization in order to be considered a hardship.
Yeah, the word they use is significant, and to Shawn's point, the significant would have to be, especially for, you know, larger employers, it would have to be, you know, something very major, and we just don't see it happening very often. But each situation needs to be evaluated.
So here's a question from Deborah, and she says, if we provide a job description to the employee's physician for them to check off which essential functions the employee is able or not able to perform, do we need permission from the employee for that information?
I mean, we would caution on the side of any time you're going to a treatment provider to get information regarding the employee that you should have a release of information from the employee.
I mean, our experience is normally physicians ask for it before they'll release it, with all the, as we've all seen, all the sensitivity around, you know, personal identifiable information. So, to Shawn's point, erring on the side of it just to get their permission seems to be the right thing. Otherwise, we're again back to, this is supposed to be a collaborative process. The more you're going and doing it on your own without talking to the employee, it kind of starts going back against the intent of the amendments.
Okay, our next question is from Antoine, asking, I attended an ADA and FMLA seminar yesterday, which we were told if we offer FMLA in an ADA situation, it only applies at a work site with 50 or more employees and a 75-mile radius. So what if you have an employee who is working remotely and not near a work site?
Meaning, do you have to give them leave as a reasonable accommodation?
I think it's asking about offering FMLA in an ADA situation, so if that makes sense to you.
Well, leave as a reasonable accommodation is not necessarily the same as FMLA. So it wouldn't necessarily apply to the same regulations that FMLA is applying to.
Yeah, the rules and the 50-mile rule is a rule under the FMLA, and so the FMLA is, while they sometimes may be running in parallel, they have different definitions and different requirements and time frames. So, if the questions are on FMLA, we follow the rules regarding FMLA.
Okay. George asks, in a union environment, if an employee exhausts their FMLA and they do not seek an extension through the ADA in accordance to the CBA, the employment is terminated. Would the onus be on the company to have reached out to the employee to remind them that such was right, or is it solely on the employee to explore? So I think that touches somewhat on what you'd already addressed, but maybe in a union environment, is that any different?
Well, the union environment doesn't really necessarily change the rules or change the regulations. And what we caution towards is that, similar to FMLA, that an employee doesn't necessarily have to come in and say, I want FMLA. If you know that an employer or an employee has a condition by which, or has a situation by which, they could benefit from FMLA, it's on the onus of the employer to offer that up, much in the same way. If you obviously have knowledge of that employee that has a disability, if they were out on FMLA, for a disabling condition, then in much that same way, we would encourage you to put language in, whether it be in their exhaustion letter or whether it be the conversation had with that employee, in order to be sure that they have, in fact, exhausted and would not benefit under the ADA.
Okay. Let's see, we have a question from Manny. He says, AMA now recognizes obesity as a disease. Does ADA recognize obesity as a disability?
Well, ADA doesn't necessarily have a list of disabilities that it considers. It really goes back to the medical condition and what is the accommodation that's being requested, and does that really, in fact, allow them to perform their job function. So if their obesity is causing them not to be able to perform their job functions, however, there's an accommodation that could be made, then, chances are that could be covered. I mean, that's a tricky one that really the underlying medical information would need to be reviewed to determine really what that is causing them not to be able to do, and what type of accommodation could really be made that would allow them to do their job.
Yeah, I think before the amendments, it probably wouldn't have been covered, but I think now, with the clarifications of the amendments, I don't think you could automatically exclude obesity, and I think more likely it would probably be covered.
Here's a question from Amy. She asks, may an employer set a standard limit on the amount of time that will be allowed for leave as an ADA reasonable accommodation? For example, 90 days when return to work is unknown.
I know that a lot of individuals that we've had this discussion with in the industry and council have cautioned away from having a set amount of time. I know that, again, at some compliance conferences, that's been it's been said that should be shied away from, that a hard line in the sand at 90 days or 180 days might not be appropriate in all situations. So I think that the key to staying, out of trouble on this is to really individually evaluate every circumstance and determining, if there really is the potential for the situation to change and when that might be, and if that's reasonable to, not have that person in the workplace for that long. And that might change, on a location by location basis, because there might be different varying situations between locations that might make 90 days appropriate in some places and 180, in others. So I don't think that having a hard line in the sand on a set number of days is looked favorably upon.
Okay, here's a question from Kathy, and she asks, what if the employee has a qualified disability that is affecting their ability to do their job, but they do not tell you about it until they are being terminated? Are we obligated to stop the termination and go back and consider the disability?
Yes. If the cause is at all related to, if the cause of termination is at all related to the fact that they have a disabling condition and that's what's leading to their termination, then we would absolutely encourage you to go back and go through that interactive process with them. Now, if the cause of termination is not related at all to the disability, then you wouldn't necessarily have to stop it. So if it's misconduct, or if it's, if they're being fired because of something, a company policy that has nothing to do with their disabling condition, then that wouldn't necessarily have bearing on their termination.
Okay. Here's a question from Shirley, and it's similar to a couple others we have. You said productivity can be a consideration when considering whether a person is performing essential job functions under ADAAA. Is that true when considering FMLA time and intermittent schedule? Can we still require full productivity?
If they're on FMLA, intermittent FMLA? No. If they're away from the workplace on a job-protected leave, they cannot be, that's considered, their productivity would have to be shifted based on their absence. Keep in mind that the accommodation is meant to, if you're on an ADA protected accommodation, that it's not meant at all, the spirit of that law was not to lessen the job for the employee. It was to, if you can give them an accommodation that makes them able to perform their job at all the essential functions of their job, then that's how they're protected. FMLA is completely different. If I'm out of the workplace for 2 weeks or 3 weeks, or intermittently for, I can't be held accountable for doing my job while I'm away from the workplace.
Well, I'll say, Shawn and Darryl, we have so many more questions to address, but we've hit our hour mark. So I believe we'll definitely be making this recorded presentation available afterwards. So anyone who wants to go back and listen or look for additional information, it will be made available. And we also have more information available on these topics on our website at sedgwick.com and on our blog at blog.sedgwick.com. In addition, you'll see on the screen under our resources here, Darryl and Shawn's contact information. So an email to them if you have any specific questions, or we may be able to do a follow-up in some way and post some of these answers to questions on some of Sedgwick's channels. So keep an eye out. It's a hot topic, so we definitely continue to cover it. And thank you so much to Darryl and Shawn for being our thought leaders. And thank you, everyone, for joining us today. Please continue to keep an eye on things, and we will follow up with you with additional information on these resources. Thanks so much for your time today.